Hello there. Thanks for joining me today on today's edition of Cleveland Conversations, where we bring you inside information on some of the most important issues facing us as a community. Today we're going to ask why cities can't stop the proliferation of guns and why they can't do what's necessary on voting rights. The fact is that cities are very hamstrung in what they're authorized to do, which is odd in light of what's supposed to be home rule in the Ohio Constitution. So we have two experts today to talk about what is the status and what can be done. I'm glad that we have Keary McCarthy, who is the head of the Mayor's Alliance in the state of Ohio. And we have Steinglass, the former dean of the Cleveland State School of Law. Thanks for both of you for joining me today.
Glad to be here.
All right, why don't you both first, Steve, let's start with you. Tell us a little bit about your background, why you're here.
Why I'm here? Well, I may be one of the leading experts in the state on the Ohio Constitution, which is something I've taught, lectured, written about. I'm the author of a book on the Ohio Constitution, and I was the senior policy advisor from 2013 to 2017 for the Ohio Constitutional Modernization Commission. So I've been involved in Ohio constitutional issues for a long time, and it seems to me the topic that we're addressing, home rule, guns, other issues that the cities may want to address, is quintessentially tied to the Ohio Constitution.
And Keary?
Well, it's glad to be back at my alma mater. I went to graduate school here at Cleveland State, so thank you for having me. The Ohio Mayor's Alliance is a bipartisan coalition of mayors in Ohio's 30 largest cities, which includes Cleveland, of course, and numerous other communities here in Cuyahoga County. We represent the city's interests primarily at the state level, and this is an issue that comes up often. Where is that line between the constitutional rights to home rule and the overriding state interests? So when we lobby on behalf of our cities to the state legislature, this is a topic of much debate, and we look forward to getting into the conversation today.
Well, let's get right into it. Tell us about home rule and what that means and what it doesn't mean.
Sure. Well, home rule, effectively is the right for incorporated charter governments in Ohio, the constitutional right, I should say, to exercise all powers of local self-government unless there is an overriding state law that conflicts with that. That's the layman's explanation of it. But I'd say three additional things about why it's important. First of all, cities are on the front lines providing some critical public services to their residents. Public safety, trash collection, infrastructure, the water that you drink. Those essential services come from our cities, our frontline providers. Public safety being maybe the most important one. It's our largest single expenditure for every city in the Mayor's Alliance. Public safety is by far the largest budgetary expenditure. So providing these critical services is important. The other thing I'll say about home rule and why it's important is, we have a very diverse state. We have a lot of rural areas, we have Appalachia, we have farmland out west, and we have a lot of cities for a Midwestern state, a lot of urban centers. So not one size always fits all. And so we want to make sure that we've got the ability to respond to the concerns and issues that the residents of our communities raise. And then the last one is just that. We are, home rule is really fundamentally about representative democracy. We represent, our mayors and council members are elected by the residents of our cities to respond to the needs that come up in a unique environment like the city of Cleveland or elsewhere. And those elected representatives have to be able to respond to those needs. If the state comes in and imposes its will from people who don't live in that community, who aren't elected in that community, on representatives of those cities, that fundamentally undermines democracy, and that's really at the heart of this issue.
And you had given me some statistics on that. The fact that very few of the state legislators that are in control represent cities. Tell us about that.
So in our state legislature, there's 132 members between the House and the Senate. There's 33 in the Senate, 99 in the House. There are, I think, 93 members of the majority party. In this case, it's the Republican Party. And of those 93 members, they really control the legislative agenda by all intents and purposes. Of those 93 elected representatives, only 5 of them live within one of our 10 largest cities in the state of Ohio. So only 5 of the governing majority in our state legislature, 5 individuals, live in one of our 10 largest cities in the state of Ohio. So, the reality is that our state legislature, because of the way it's been gerrymandered, really is not representative of a big portion of the state. Our 30 largest cities represent a third of the population in the state of Ohio, but of the majority party governing in the state legislature, very few of them live in our cities or represent our cities.
So what you're saying is that rural Ohioans are basically dictating to urban and our suburban members what they can and can't do.
Yeah, I think it's important to be sensitive to the urban-rural divide, so I wouldn't exactly put it that way, but I think what is true clearly is that there is a big misunderstanding, and important need for communication, the unique needs of cities to lawmakers who do not live there and do not represent those cities themselves, and that's the role we play at the Ohio Mayor's Alliance.
So Steve, I thought home rule is supposed to do exactly what Keary is talking about, is allow cities to govern their own residents.
Indeed, it was supposed to.
And where are we?
Well, we have some problems. I mean, first of all, home rule isn't this new idea. It's been around in Ohio since 1912, when the Ohio Constitutional Convention of that year proposed the Home Rule Amendment, and the voters approved it. For most of that period of time, home rule has been honored. In the last 20 years or so, there's been a change in direction, and both the letter and the spirit of the Home Rule Amendment have been, let's say, ignored. And the political reasons why that happens are complicated. But for someone who's looked at it from a perspective of a historian, a lawyer, it's really quite appalling what's happening. It's fair to say that the General Assembly, taken as a whole, does not respect home rule, either the letter of the law or the spirit of home rule.
But home rule is still on the books. So tell me, how do they get around it?
Well, I don't want to get too complicated, but let me just, take a chance. In 1912, Article 18 of the Constitution was approved, the Home Rule Amendment. Section 3 creates a delegation to cities of the powers. Keary mentioned them a moment ago. The power of self-government and the power which we sometimes call the police power, police, sanitation, things like that. If you look at the language from Article 18, Section 3, what you see is the power of self-government is not qualified, but the police power is. A law in conflict with a state law in conflict with a city ordinance prevails. But, and this is really the biggest but, somehow the notion has evolved that the state can preempt local legislation. And preemption has become the problem. Preemption is not accepted by the Ohio Supreme Court. It's not consistent with the Ohio Constitution. It's not consistent with the debates in 1912. Preemption's a very slippery word. Narrowly, preempt is sometimes used as a synonym for conflict. That's okay. A state statute can conflict with a local ordinance, and in some instances can prevail. Preemption is being used, however, as is sometimes called field preemption, where the General Assembly seeks to wall off an entire area and say, city, you may not legislate in this area, end of story. And that is simply inconsistent with the approach that the 1912 convention delegates proposed, and indeed what the Ohio Supreme Court has proposed. It gets more complicated, and I don't want to make this a legal seminar, but the Ohio Supreme Court has said that for a state law to preempt, to override a local ordinance, it has to meet multiple criteria, one of which there has to be a comprehensive regulatory scheme. Just stick with that for a moment. The state simply can't say, you can't do this. That's not regulating, that's prohibiting, that's not allowed. The state can say, we are going to regulate it. We're going to regulate navigable waters, or we're going to regulate environmental issues involving the quality of water, groundwater, let's say, which may affect multiple entities. Regulation, comprehensive regulation is acceptable, but preemption, walling off an area is not. The General Assembly does it. The court has been not as aggressive as it should have been, in my perspective, in holding the legislature within its lane.
All right, let's hold that for 1 second, because
Sure.
that's Stephen Steinglass saying it should not, that the Supreme Court's not doing what it should. But in fact, the Supreme Court has done quite a bit in terms of preemption, as I understand it.
Well, it has found conflicts and let state law prevail, but it has never endorsed preemption as a
Okay.
doctrine.
I probably used the wrong terminology, but
That's
it has.
okay. Everyone, but that's the problem, Oren. Everyone does, and that's why I wrote an editorial, an op-ed in the Dispatch a couple of, I think it was a couple of months ago, in which I said the General Assembly doesn't have the power it thinks it has when it comes to preemption.
Well, Keary, talk about some of the things the Supreme
Yeah.
Court has prevented cities from doing that they'd like to do or wanted to do.
Yeah, I would say, just to put a finer point on what Mr. Steinglass outlined, which is what we see at the front lines on representing cities at the State House, is state preemption laws are really used to resolve policy disputes between state and local leaders. And that, I think, is at the heart of where the conflict is. That's not what the Ohio Constitution intended. If the state legislature disagrees with a city on how they're implementing, certain regulations that aren't otherwise outlined in the Ohio Revised Code and comprehensive on a statewide level, the state should not be able to just come in and stop them from doing that. It is not a measure, it is not a mechanism to resolve political differences or policy disputes between
But give
state
some
and local
examples of
levels.
what the state has stopped.
Perfect example just happened most recently, I would say, last year. A few of our cities were trying to prevent a concerning and dramatic rise in teen tobacco use. The tobacco companies use flavored tobacco and vape products to target teens. Our schools were coming to our cities. They were saying, we are seeing more vapes in our bathrooms. We have a spike in these incidents with our students using tobacco products. So the city of Columbus tried to regulate teen tobacco use, regulate flavored tobacco and vape products. And they passed a local ordinance to try to do that within the city of Columbus. The state came in and said, nope, you can't do that, City of Columbus. And they put a provision in the state budget that would have prohibited the local regulation of flavored tobacco products and vape products. That's one example. Now, that had a different ending than some of the other ones, because the governor, at our request, and numerous other organizations who care about the health and well-being of young people and not becoming addicted to tobacco, encouraged the governor to veto that provision, and he did. So that one was held at bay, although we did that on 2 occasions, by the way. But that is a good example, one specific example of this tension between that cities face in terms of trying to be responsive to the concerns that their residents who elect them and craft policies that address solutions, versus where the state comes in and says, no, we just disagree. You shouldn't be able to do that locally, and we're going to just blanketly prevent cities from doing it.
So right now, on a local and national basis, we have a gun proliferation problem. I mean, clearly, violent crime is rampant, and violent crime with guns. And cities, at least in Ohio, have tried to various things to limit the uses of guns, the availability of guns with background checks and magazine limits and the various efforts that have been made. Many of your member cities have tried that and have been told they can't do it by the state legislature. Is that an example of what we're talking about?
Yeah, there are many examples, so I don't want to take over the conversation, which is why I just stopped at one. But yes, the regulation of local firearms is another example. Back in, I think, 2019, the state preemptively tried to pass a very broad preemption law that would prohibit local governments, cities in particular, from regulating really anything around firearms or the selling of ammunition. So the discharge of a weapon, the sale of a weapon, all of those things arguably fall under this blanket preemption. I'll let Steve talk a little bit about some of the legalities of it, but the reality of the impact is that, gun violence in Ohio is on the rise. The gun death rate in Ohio has doubled over the last 20 years. During that same period of time, the state legislature has made guns easier to buy, easier to sell, harder to prosecute, easier to access. And so we have had a challenge with keeping guns out of the hands of people who shouldn't have them. So cities said, okay, state, if you're not going to help us address the challenge of gun violence, we're going to start to regulate how guns can be sold through straw man purchases was one specific example. One of our cities tried to limit the amount of high-capacity magazines that were sold and owned in the cities. But that has led us to a legal dispute between the state and a few of our cities. The state arguing that no, under this preemption law that passed back in 2019, you have no authority to stop. I think the city of Columbus was proposing to limit high-capacity magazines at 30 rounds or more in one magazine, as one specific example. The other example, and then I'll stop because I think it's important. The city of Columbus also tried to ensure that your firearm was locked and stored properly to prevent children from getting access to these weapons and doing unspeakable damage to themselves and others. Well, that in fact happened while Columbus had this ordinance on the book. A guy left his loaded firearm in the couch cushion. A toddler got access to it. It discharged. Fortunately, the toddler wasn't killed. There was another toddler in the room. The city of Columbus tried to put that guy in prison for 10 days for not following the city ordinance that it would require safe storage. The state of Ohio stepped in and said, no, city of Columbus, you can't do that. You cannot regulate safe storage of firearms.
So, Steve, you mentioned that you had done an op-ed a few weeks ago or a month ago on this preemption issue, and it certainly involved the gun example, where the state had taken the position previously that it had adopted a comprehensive system of regulation, and therefore when cities tried to do something, it was in conflict. And now you have pointed out that there's been a major change or potential. Can you talk about that?
Sure. Let me just correct, Keary, one little way. The state preemption statute on guns dates back about 15 years ago. It's been amended a number of times. So there's a broad prohibition on local regulations involving guns and even knives. The Ohio Supreme Court upheld that, said it was okay, because at the time it identified multiple state laws that constituted comprehensive regulation. So one of the great ironies that's taken place...
So if there's a comprehensive system, that makes it easier to say that there's a conflict with a local
Yes,
government.
absolutely. That's a prerequisite to saying that. One of the great ironies that exists is that the gun lobby has been so successful, it's convinced the General Assembly to deregulate, deregulate, deregulate. So there are no state laws on banning or addressing assault weapons or the size of magazines. No, the restrictions on concealed weapons have been eliminated, virtually eliminated. The state gun safety legislation is essentially non-existent. So even though the state attempt to quote unquote preempt local gun regulations was upheld over about 15 years ago, that issue will eventually come back to the Ohio Supreme Court because the facts have changed. There is no longer comprehensive regulation, and what the quote unquote preemption in the gun area really is what I would call a naked preemption. The General Assembly is simply saying local government, you can't do this, and that is not, in my opinion, an acceptable approach.
So let me cut in for a second, because I think your argument here is ingenious. It's saying that because the state had a comprehensive system, but now doesn't because they've eliminated many of those regulations, that by the gun lobby succeeding in reducing the limitations on guns, in fact now cities have an opening to come in and say you're not preempting the field, and therefore we can adopt our rules.
And those issues, yes, and those issues are being litigated in cases out of Cincinnati and Columbus, two cities that have been very, very aggressive in trying to challenge the orthodoxy of state law in this area. And I should say the comprehensive requirement is just one of several requirements that have to be met in order to uphold a state regulation. Again, I don't want to get too legalistic, but it all boils down to a simple point. If the state is actually regulating an area, then it's legitimate for the state to say, look, we should have a statewide solution to this problem. But if the state, as a matter of policy, is saying, no, you can't do this, then it's a different kettle of fish. It's a different situation. We're talking about guns, but it's not just an issue of guns. It comes up, for example, unemployment. I mean, we had provisions in Cleveland, the Fannie Lewis law, which would have required government contractors to employ a certain percentage of people who were residents of the city. We had a municipal residency requirement requiring employees of the city to live in the city. There's been discussion around the state about minimum wage legislation adopted by municipalities. In the first two cases, the Ohio Supreme Court rejected the Fannie Lewis law, rejected the municipal residency requirement, and thus rejected the home rule aspirations of cities. The minimum wage issue has not come up before the Ohio Supreme Court, but as Keary explained to me the other day, the General Assembly has sought to prohibit cities from adopting minimum wage laws that are higher than the state minimum. So it comes up in other areas. It came up in predatory lending some years ago, where cities tried to limit the ability of lenders to make these very, very objectionable loans. The state already prohibited some of them. The cities wanted to go further. One can say they are in conflict. One can say that the work of the city simply supplemented what the state was doing. In any case, the Ohio Supreme Court rejected the city's approach. So it's a complicated issue, both politically and legally, and I think I really commend Keary and the mayors of the major cities for trying to push this issue, not just in the area of guns, but in the area of governance. And governance is really the key, because unless cities are free to respond to the needs of their constituents, their residents, we're going to have very, very stilted government.
Well, Keary and his members have done a great job, but I must say you've given them a great roadmap to use, and I think that's going to make a lot of difference. Keary, in a minute or less. Do you think the cities are going to be able to win their cases on the guns?
I think we have a fighting chance. I do, and I think this issue is important because, as Stephen said, it's complicated and it's a little bit wonky for the government types, but it's incredibly important. It affects everything from environmental regulations, public safety, wage and hour disputes. So, how it affects real people is genuine. And if local governments cannot respond to the unique demands of their particular communities, people are going to feel the impacts of this, and that's why it's so important for people like Stephen and others to raise these issues, understand what the history of the Ohio Constitution, why this constitutional provision was put in the first place, and so we have a lot of work to do, but I feel like we're on strong footing.
Steve Steinglass has created this roadmap for challenging the so-called preemption approach that's been used for years to basically stomp out cities' efforts to govern themselves. And I think it's very exciting that this is now moving forward, and I appreciate what you've done, Steve, and what you've laid out. And Keary, I appreciate the efforts of your members and you for pursuing this. As you said, it's incredibly important for the people in our communities to be able to govern themselves. That was the intent, as Steve started, of the home rules provisions, and they've gotten lost, but hopefully they'll be found again. And so I want to thank you both for what you're doing and for coming in to explain this somewhat complicated but also important area. Thank you both very much. And thank you all for joining us today.
Well, thanks for having us.
Yes, thanks. Good conversation.